Commission meeting to order. And first thing on our agenda today is the approval of minutes. And also, George, you are a voting member today. Looks like we're. Mr. Tonkel's not here, so if you want to move up here, you can, or if you want to stay down there, it doesn't matter. Easier. Okay. So first order of business, the approval of the minutes from May 13th. Do we have any a motion for that and then discussion?
So moved.
And a second?
Second.
Any discussion? Any changes need to be made or?
We're under one of my names, the first one, there's a, what is it? Efficiency, it says deficiency. It's simple, it doesn't mean much.
Okay, do you know what page that's on? And do you know where that is for Sherry? We'll make that change.
I'm sorry?
It's on page 2.
It's the first thing that's under Blumstein.
8th paragraph down, Sherry's. Page 2, 8th paragraph down. So with that change, all in favor? Aye. Motion passes unanimously. Public comments. Do we have any public comments this morning?
Good morning, Mr. Chairman.
Good morning.
My name is Charlie Wilson, 2134 18th Avenue in the city of Vero Beach. I'm a city resident. Just wanted to step up for a moment to kind of remind ourselves of where we are. I was looking up some quotes from before the election in 2013, and there were a couple of them that were sort of striking. There was one, all winds seem to point towards 2014 close of the sale to FP&L. That was Amelia Graves in 2013. I expect to close, my guess is November 14, but it all depends on FPL offering FMPA enough money. Richard Winger, September of 2013. The city of Vero Beach has sold its electric system. Several referendums and city council votes make the will of the people very clear. Amelia Graves, 2013. And there are 2 pages of these, on and on and on, about where we were. Now, the reason I rise this morning is that when you jump 6 months in the future from that time, last Friday at the Men's Republican Club, where I attended, was addressed by Mayor Winger, who said, the deal is dead, get over it. That's where we are. The deal is dead, get over it. So I don't believe that the deal is dead, and I absolutely will not get over it. I don't think that is a plan towards the future. And with this commission, one of the things that I wanted to request when this commission considers things is to remember that the stupidest thing we ever did was get into an OUC contract and an FMPA contract. The second stupidest thing we could ever do is stop trying to get out of these 2 onerous contracts. There are pathways forward to getting out. We'll be going through those. They are legal, they are regulatory, and they are legislative, with all kinds of advantages that have been given the FMPA, being able to operate as a monopoly and so forth. There comes responsibilities. And the thought that either we don't have a means for challenging the FMPA is absolutely wrong. I am willing to do anything, I mean anything, to get out of these contracts, because contrary to popular belief, or some belief, things can get worse, and they can get worse fast. And as long as we take the position that we are simply to get over it, and we are simply emboldening them to be able to pick up numbers like 42 million. Why not 42 billion? The only good thing that we have in our advantage is that the $200,000 audit that was in the state budget was signed by the governor. And with the FP&L contract, there is no reason not to leave it on the table, at least until the completion of the FMPA audit. We do have a path forward. It's going to be longer now that the deal has been killed. Negotiations have been undermined. We've gone through a series of steps that have gone from a done deal to a dead deal in 6 months. So all I can say is that this commission, I would like to see, and I would like to ask this commission to continue to move forward, to find pathways for relief for the citizens of Vero Beach. Do not be dissuaded. Just because it's tough doesn't mean it's not. We're not able to do it. But we now have to take a longer path. A negotiated settlement would have been preferred by everyone. But we simply will not ever achieve that because, frankly, the FMPA will never let us go. Thank you.
Thank you very much.
Mark Mucher, 617 Indian Lilac Road. Following up on that, I too am interested in where things go from here, and although I don't have anything to say about it, I'm not interested in getting over it either, or bending over, or doing whatever the council seems to advise us all to do in terms of trying to stay in the utility business. But we don't have a choice in the short term but to stay in the utility business, and so we do want to maximize that. Now, one of the ideas that's been floated is mothballing the power plant, and I've asked Jim O'Connor in your last meeting and at the last city council meeting if that wouldn't cost more than it would save, at least in the short term. And I think the answer I got was yes, it would. And at this point, it just becomes a matter of trying to quantify that. If we were to indicate a desire to mothball the plant, then the OUC reserve capacity calculations that the utility director did such a good job of explaining to us last time, or maybe it was the time before, would kick in, and it would cost literally millions of dollars a year to buy power that we probably don't need except in a super peak kind of situation. And so I'd encourage you to ask the council and the staff to look into the details of what that break-even might be, the costs of mothballing the plant, furloughing the employees, and those kind of things. Thank you.
Thank you very much. That's a good question, and it's something that I had not considered. We just looked at these capacity charges, Jim. Do you recall, does anybody or anybody else recall what it was per megawatt hour? Because we'd have to increase our capacity charge by 55 megawatts.
I don't have that number directly in front of me. It's in the contract, and I think it's $14 or something. And we were going from 93 megawatts capacity needs to 99, as I recall. But we've asked OUC to go back and reevaluate that number. But I will say that in the short term that we've seen the heat demand has risen here in this first part of the summer. But it's my understanding OUC is revisiting that demand and the capacity number.
Which is good, and which we asked them to do that.
Correct.
But I guess the thing is one of the costs, an ongoing cost of mothballing the plant was we would have to buy more reserve capacity from OUC.
Not necessarily from OUC, but the issue really is, and we just to frame this up for you, we're in the process of putting together a letter to ask FP&L to do a transmission study. That's going to be the critical element to this, getting capacity up to the city of Vero Beach and what that would entail. I have been in discussions with FP&L and told them that this letter is being put together. It has to have certain items to be addressed. In that letter, it will talk about not only the transmission that needs to come up, but also the availability of capacity, because most of this capacity would have to come from the south. In my discussions with FP&L, they seem to think that they would be willing to, on the open market, quote us a price for capacity. But at the same time, if we put this RFP out, I'm sure that OUC would also quote on that capacity. Now, to dovetail that in, one of the items on the SWOT analysis that we have briefly talked about that we'll be reporting to the Finance Commission is to renegotiate the OUC contract. One of our challenges right now is the OUC contract is sort of in abeyance because of their part in taking the power supply agreements, but I think we're going to be able to get over that. And maybe if we can renegotiate and we have capacity needs, that may give us at least an opportunity to try to renegotiate some of that pricing. As you know, we put into the contract a fixed escalator, which right now doesn't really match what the market is what the market would bear right now. So we would try to renegotiate that, and at the same time, if we have capacity needs because we have transmission, that gives us a little more flexibility to work with. And so those two elements will be a part of it. Going back to the latest statement, short-term decommissioning and mothballing the power plant will have cost. I mean, we've got to take out the remaining fuel that's in the tank itself. Now, we were very fortunate. We sold the fuel that we took out of that first tank, and we were able to actually have about an $800,000 cash payment to the city in that deal, which included inspection of all of our pipes, which everything turned out very well on that. So we would have to take that fuel off-site. We also have some degreasers and these type of materials that are on site that would have to be removed in order to mothball the plant. And then you're going to have some cost of security, making sure that the facility is in a secure situation and having some type of guard or something to go by and check the plant out, assuming that we can secure the gates with locks, put cameras on there, and at least temporarily secure that before we start taking the plant down, which also will entail a cost that we need. We will not really itemize that at this point, because what we would like to do is just really take it out and decommission it there, see if there's any value in the materials that are in the plant. Because if we get to that point where we have the transmission and we have the capacity under contract, then there's a possibility on the open market there may be a place where we can sell some of the parts out of the plant itself. So those are the type of things that we're thinking about as it applies to the power plant. The assumption is that we, under our present contract, could not compete in the open market in trying to operate a power plant. It's about a $4 million a year cost to us.
Yeah, last Thursday it ran. You know why?
It ran.
Yeah.
Well, now we do a lot of testing on that. We are required to make sure our units are up. And as you recall, we were having problems with Unit 2 and 5 even after the overhaul. The our inspectors came in and the contractor came in and made those repairs, and it might have been what you saw at that time that they were running the plant and doing the testing. We found that it was a minimal issue that was there. We have yet to arrive at an agreement of who pays what price, but the number is relatively small, so we're as what we know today. So that was very good, but we've had to go through the testing of 2 and 5 to make sure that we can put it online and have it available. Unit 3 still has some issues with some of the tubes. I have one of the blown out tubes in my office if anybody wants to see what one looks like. But we're probably not going to invest very much money in Unit 3 going forward. It's not required under our contract. It was a backup for us to make sure that we could address any brownouts that we would need.
I looked at the going forward increases every year, and I don't think we have a problem with that. What we have a problem with is the fact that that hasn't happened, and we need to re-ratchet the starting point. And if we could do that and continue with the growth, things would look a lot better and a lot more real. So maybe that's a different way to approach it. I don't know.
There's no question. Growth would be a good factor to have. In our restricted territory, we do have some growth taking place, as everybody can see around town. Building permits are being issued. Growth does have and is a part of the solution to the problem. The fact that our increases were signed several years ago, and it's not really reflective of the market. Now, if the market was reverse of what it is today, obviously having the built-in increases that would not reflect the higher cost would be a good thing. But, you know, it was sort of, we just sort of bet on the future in that case, and in this particular time of our history, it was not really a good bet. But growth, obviously, and sales definitely are partial to the remedy of the problem.
You know, I didn't. I was saying that the growth rate is probably right, but somebody needs to say, did it happen? You know, if we can put that clause in the contract, if it didn't happen last year, then at least part of that needs to be thrown back into where we start from today to add that, continue to add that growth point.
Good.
So in other words, we got a line going like this, and we just kind of shove it down if we can, the whole thing.
Right. And
they might be more amenable to something like that than to changing the basic rates.
Right. We have to keep in mind that, as has been reported by OUC, they're very happy with their contract, and that we've got to come to where it's going to be a win-win for both parties if we're going to negotiate that, and that's the way we'd try to enter that. And again, talking to FP&L, they seem to be amenable to making sure that we can have those type of conversations.
Got a question. In the letters that we got, the examples, it says something, example 2 is that if Stanton 1 was closed, it would cost us $2.8 million. But what does that do to what we get? We get something from that. We own part of that, right?
Yes, sir. We own part of the plant. And that's what is the contingent liability. You break these two things down that are part of our FMPA obligations. One is contingent liability. Those are the ones in the letter they say are not quantifiable because they go for the life of all 3 plants, St. Lucie, Stanton 2, and Stanton. And so if anything happens in there, we have to pay our proportionate share of what that would be. The example that was used when we were talking to FMPA is Crystal River. Crystal River had a crack. They had to decommission Crystal River, but it's going to be another 50 years before Crystal River really is addressed and cleaned up. And everybody that's a party to that is going to have an obligation to that period. So what they're saying in the contingent liability, that if Stanton 1 was closed down or there was some type of class action lawsuit or whatever the case may be, the federal government comes in and says coal's bad for the world or something, which they're very close to, we would be responsible and liable for our exposure of that cost. But you are exactly right. OUC is still responsible for making sure we have the capacity to address our needs wherever they may get that. And
but Stanton 1, how much do we normally get from Stanton 1? We got 58 from Stanton 1 and 2. How much of it is Stanton 1?
Actually, it rotates back and forth. because, as you know, since there's been a low demand, they typically rotate one of the plants. One of the things that's an indicator, if you'll look at FMPA projections of cost, they will have one Stanton plant at 75 and the other one will be 135 or something. Typically, when you price it high, what you're doing is taking that out of the market, because every day they wake up with a new world and it says, I'll run Stanton 1 at 75 and I'll run Stanton 2 at 135. Unless the price of power gets to that 135, they don't turn Stanton 2 on. And so with the low demand right now and a high supply, you typically will only have one of the Stanton plants running. They have to run one of those plants because that's a no discharge site. Sitting behind there is the Southern Company gas facility. And so OUC is obligated under contract to make sure that that discharge from that gas plant is taken care of by one of their Stanton plants. So they have to price it economically in order to have one of the plants going. But the bottom line to the contract is, A, we own a piece of both of those Stanton plants, but the second thing is that OUC is required and obligated to provide us capacity to meet our loads. And so that's where we come from.
Well, the thing that bothers me, I got an email from the U.S. Energy Information Administration yesterday, and they're talking about a carbon tax putting in 15, and they got various scenarios, and it's talking about $10 a ton of CO and what that would do, and that would just ruin Stanton 1 and 2, I would think, because they're talking about it going up 5% a year after 15.
Or if you notice in the letter, it talks about improvements or modifications to the Stanton plants in order to meet the new air emissions.
Yeah, $105 million.
Yeah, and we would be responsible in our rate structure for the proportionate share of what that cost is. That has two impacts. Number one is I'm not sure that would come out of their operating costs, so there would be another borrowing taking place. And one of the concerns that everyone's had is that it extends the life of the facility because you may refinance or borrow farther out in the time frame. But again, whatever that number is, and if the air quality standards continue to change, which everyone assumes that they will, then this might be one of those 10-year fixes, and in the next 10 years you have another fix. But again, because of the way that the Stanton facility is set up with the operation of the Southern Company plant behind it, it makes it a little more difficult than if it was a standalone coal plant. But we will have our obligations assigned to that.
Okay, I got one other question. In previous correspondence, there's been talking about FMPA wants another 100 megawatts from Turkey, nuclear plant. Does the board actually approve that, or just FMPA be able to do that on their own without asking the approval of the board?
FMPA cannot do anything without the vote of the board. FMPA is an existence of the board of directors. So the answer is the staff cannot obligate them to that acquisition of Turkey Point. And it's my understanding the Turkey Point discussion is pretty much off the board. I may be wrong in that, but when that came up, at one time FMPA was interested, but the last I heard that they had some concern or speculation that Turkey Point would even get off the ground. So, but the board would do it. And the way that FMPA operates, let's say they take 100 megawatts. Well, they don't just take 100 megawatts. What they do is they find cities that want to purchase a proportionate share of that. So if the city of Bartow said, I want 5 megawatts, and it may only add up to 35 megawatts, well, that's all FMPA will acquire in that facility.
So if we wanted some of it, we'd have to go and buy it, and that would be another mistake.
Depending on how the contract's written. But yes, at this particular time, buying into a plant itself as opposed to the open market would not be a real wise decision.
Okay, thank you.
I think some of those questions heard might come back up again in the context of Jim's discussion, but Mark, did you have a question?
Mark Muture again. Yes, other than reminding you we're still under public comment. Two things about Jim's answer to my questions. I believe he failed to mention the considerable cost of laying off the employees at the power plant. And we're going to need to quantify that, of course, too, if we ever are to figure a break even or a savings or an increased cost. And it seems to me that closing the power plant will increase the rates for at least a period of time. But he mentioned the transmission thing as a thing we're going forward with, and I just wanted to ask how we would pay that estimated Florida Power and Light estimated the transmission upgrades on Vero Beach's side to be $7.5 million. I don't know whether that's still the case, more or less, but how we would pay for that. If that was in rates, that would more than wipe out the rate decrease we just had. And so I just wanted to ask that question too as a follow-up. Thank you.
Okay, well, I think we either have to pay for it through rates or through funding, which we would then pay for through rates. So,
Obviously, ratepayers would have to pay for it. You're negotiating a capacity contract at the same time you're doing transmission upgrades. Gives you, again, another area to negotiate pricing.
thank you. Any other public comment?
Are we into all the letters and stuff and general comments about this?
Well, we're going to follow the agenda, which we're going to close public comments, and then
okay.
we're going to go
I'm
into
sorry.
old business,
Go ahead.
which will get us there. So, yes,
I
sir.
was ahead of you.
We sort of jumped a little ahead with some questions. So public comments are closed. We don't have any new business and old business. We have, first thing is an update on the status of the electric sale.
Yes, the electric cell at best is on life support right now. We have had issues pertaining to our power supply contracts. We thought we had those addressed, and we were moving forward with the assumption that the details could be worked out. Based on the two pieces of correspondence, one from OUC, one from FMPA, obviously that did not work out. We are still, or I am still in conversation with Florida Power and Light to see if there's any other options or alternatives that we may have in that, because the power supply contracts right now are the most critical issues. I think we have a willing buyer of those power supply contracts. The question is how you have the contract between them and FMPA work out, and that seems to be very, very difficult at this point, if not impossible, so we have to see what other venues are there. You received those two letters from OUC and FMPA, and I started to elaborate on this a little earlier, but you got two areas of issues. One is your contingent liability, and the contingent liability are those long-term costs associated with just owning a piece of the plant. That was the number that we have been trying to quantify, because that, and you've heard us speak a year ago at least, where we would have liked to have been able to go out and buy a bond or buy insurance policies or whatever the case may be to cover whatever that number is. And if you can't quantify it, you can't insure it. There's no way to get insurance for an unquantifiable issue. So that's another major blow as it goes in trying to address the long-term exposure. Then we have the stranded cost issue that has recently come to a number. We have been talking about stranded costs again for about a year, and we had identified.
Jim, can we do stranded costs after we talk about the letters from
Sure.
to and from the OUC, and we'll just pick that up at the end, because I did want to
That'll be
go
fine.
into
Okay.
that. And
That's the $46.1 million, but there's another, if you read through the letter, there's another $3.8 million potential, and that's on the Taylor swaps. We have asked on those two letters to help quantify or to help us understand how the 46.1 million was arrived at, and our attorney has been talking to the attorneys for FMPA. One of the issues that we have is in Vero Beach, we've explained to FMPA and others that we're very sensitive to redacted documents. And so they had, in order to get to their numbers, what we were being told, not what I have seen, is that they had to go to other utilities in order to get some of those numbers to address and making quantifiable under the letters. And so therefore those utilities say that they have proprietary information exposed in some of their analysis. So we are still going through that, and hopefully we'll arrive with some document. And it may be redacted. We'll have to take it at face value.
I do want to talk about the cost and the all requirements project.
Okay.
Okay, but I'd like to talk first, what's on the agenda is the, just to go into the back and forth between the OUC and the FNPA and their contract requirements, which Mr. Whittle made reference to, I believe. And so we can just understand and try to break down a little bit why the OUC is no longer willing to go through with the deal, what FNPA is requiring, what OUC is requiring. So if we could kind of look at that a little bit, and then we can.
Oh, I apologize. I agree. I got off tangent again. But, yeah, the way the letters and what happened between FNPA and OUC are the bond councils and the security for the pledging. What happened when we first got the contract with OUC, they felt like if they took our power supply contracts, they would sit in the same position they have always sat. They are a power provider, not a power buyer. And so the assumption was, on our part as well as OUC's, is that if they took our power supply agreement, since they owned really the generating units, that they would still sit as a power supplier to FMPA and not subject.
Because right now, OUC produces the power. They sell to FNPA, who
Members.
sells it to FNPA, who sells it to the members, which is us. And so when OUC was going to assume our power contracts, they thought that effectively that middleman issue in terms of the bonds would go away.
That is correct. And they would stay as their role where they are today with FMPA and not subject to FMPA decisions on, for example, futures of fuels and that kind of stuff.
Okay. And future refinancing and.
Right.
Okay.
Future funding of facilities.
And their problem was, as I understand it, correct me if I'm wrong, the FNPA required that the FNPA bonds would take priority over the other OUC bonding, and OUC could not put their other bond, their ability to bond and their current bonds at risk, and there would be a struggle between priorities, a difference in the priority of resolution of any issues if they came up. Is that's
pretty close to where it is, yes. And that comes back to their position with FMPA.
Okay.
Right now, they are a standalone. They have their own business model. They have their own bonding capabilities, and they have their own priorities as to how their bonds. And what you said is correct. FMPA wanted to be at that upper rank, the ranking of the bond issues as it affects the kilowatts being generated that are previously owned by the city of Vero Beach.
Okay. I mean, that's a relatively small number to see in terms of their overall bond issue and their production issue.
That is correct. And the other thing that sort of came in the conversations, and this happened about 6 months ago, which was a flag to us that we needed to really work on that, is talking about a kilowatt generated out of the OUC facility. OUC sells on the open market For example, we ran our plant one time for a couple of days for the Southern Company needed power. So OUC dispatched our power to the Southern Company. But they wheel and deal with Florida Power and Light, Florida or Duke Energy now, or any other private utility. But they do it on a short-term window. And as you know, even though there's been discussion about the IRS regulations say you don't have a contract longer than 3 years, they do it on a daily or a weekly basis. FMPA started saying, wait a minute, if you're dealing City of Vero Beach kilowatts, then you come back under, you have to get permission and authority from FMPA to be able to sell those on the open market. And OUC's position, which made very clear to me, was there is no such thing as a yellow and a green kilowatt. We sell kilowatts coming out of our plant, and so therefore we find it very difficult. So we had several discussions over how you identify whose kilowatts are coming from the facilities, and that's why we changed the contract a couple of times by saying they are not facility specific, they are system-wide kilowatts, but we still had challenges, and it really came back to the bond councils at the end of the day. And the bond councils related it back to the role and the position OUC would be at FMPA under the terms and conditions of taking our power supply contracts.
Okay, and that's where OUC was unwilling to be subject to FNPA's terms, and FNPA is unwilling to modify the terms. Would they have to then modify the sales agreement, which would require the approval of all the cities?
Yes, the requirement of all city approval, we lost that battle a year ago. So we felt like we had to, that we would ultimately have to go to all the cities and get their approval. So those bond councils would be recommending, i.e. OUC's bond council would be recommending to the OUC board, and then the bond council for FMPA would be recommending to their board of directors and ultimately to the cities.
Okay. All right.
When OUC gets down, OUC never buys from anybody else and resells?
I'm sure the answer is yes, they do buy, but most of the time they are 100% load producer plus reserves. But yes, they do buy on the open market for themselves as well. And if they can buy cheaper power, and that's one of the reasons they can turn their Stanton plants off, is that they will go and buy gas or somewhere else. So.
Okay. Yeah, some of the cost, Herb, you were mentioning the cost of the fixed cost in the Stanton 1 and 2. Did you, were your questions answered on that? Mm-hmm. Okay, I don't know. Any other questions on these, on the letters, the back and forth?
Mr. Chairman, if I might, and this may be a naive question, but you were speaking about the long-term liabilities and the possibility of buying insurance and what have you, and that was not acceptable because you can't quantify them. The municipality has an unlimited life and has the ability to tax. And as a consequence, it would seem to me that as long as we're required to stand by those long-term, whether they're quantifiable or not, it seems to me that just being obligated as part of the contract should be sufficient to cover them, whether we know what they are or not. So why are we making it a big deal when it seems to me that by virtue of the city of Vero Beach being an entity that has an unlimited life and has the ability to tax as necessary to meet its obligations, why can't we just forget about that part of it and just move on?
Because under FMPA, they have no access to our taxing authority or to the entity of the city. We did float the possibility of having, because it really boiled down, as I was told by one utility director, Jim, you're taking 34,000 customers out of our market plus growth. And so therefore, those are the the assets that we hold as part of your contract. So we came back and said, well, wonder if Indian River Shores, the city of Vero Beach, and the unincorporated part of the county that had our customers pledged their general obligation to cover those cities. I mean, to cover our indebtedness. Now, that would require, for example, referendums in all three of those areas to do, and then therefore they would have the $34,000. That was never discounted. But then when we ran into the hump with the bond council, then that's because we still have to transfer the power supply agreements to somebody. And so we would have used that as our contingent liability fallback of doing it. Now, Mike, just to be very honest with you, even though I was part of those discussions, I made it very clear to all the attorneys I had some real hesitation and reservation about that, because you were obligating 3 local government entities for their future general obligations, and it just from a business standpoint makes it sound pretty onerous to me, and it looks like, you know, the same type of contract we're in now, that we're out there for 45 years or something. This would be a similar type of thing, but we would really be pledging not only our ratepayers but their properties. Mm-hmm. Right now, the only pledge that FMPA has against us are the ratepayers and the ability to put a bill in their mailbox based on consumption.
Okay, thank you.
All right. Thank you. Go.
I think basically it appears that we're doing the right thing, but I'd like to kind of officially, for myself anyway, right now, say that what we need to do is concentrate on those letters and on these obligations and see if there's any possible way to get out of them. And if there is, we need to go back to FMPA and say, any of these, that we're not obligated for this particular one for the following reasons, our lawyers, et cetera. And say, now it's your...
Have you jumped into the All Requirements Project?
I'm sorry?
Have you jumped into the All Requirements Project?
Have I...
Are you discussing the letter about the cost of withdrawal
Well,
from the All Requirements
FMPA
Project?
cost the obligations that we're stuck with, that they say we're stuck with.
Okay, under the Stanton 1, Stanton 2, the OU, what I'm trying to do...
All of them.
What I'm trying to do is I'm
All
just
of
trying to
Yeah.
bring structure to the meeting so that it's...
Okay.
so that the public can follow a logical progression of our discussions and do a little bit of introduction when we switch to a new topic, and not just...
Okay. Well,
Because we have all this information, and Jim has all this information. We can have this back and forth,
Mhm.
but we have to realize that part of what we do is at the public service so that the public can understand. And I think I understand where you're going, and I appreciate it, and that's where I want to go next. But what I'd like to do
well,
is to close out this section of discussion.
okay, so we're now
Move into the
talking-
next one.
We're now talking only about the all requirements.
Well,
project, or the
that's what
the power
I'd like to
supply
do, but I want to see if there are any other questions relative.
And if you put it under 2 general topics, contingent liabilities are our obligations and ownership of the plants, and stranded costs are the all requirements. That's a pretty distinct differential there as to what the contingent liabilities is, the unquantifiable. The stranded costs are what you have in these numbers.
Right. So, if there's no other questions or questions from the public about the OUC to FNPA and to us letters, it's not on the agenda, but we did get this letter. It wasn't in the online package, but there's a letter on June the 4th to Jim from the FNPA, and I think we all got a copy of that. The subject was estimated Vero Beach ARP termination payments as of June 2014. And just so a little bit of background, since we have requested to withdraw, we've sent the notice that we are withdrawing from the all requirements project. There is a section 29, subsection C1 and subsection C2 deal with the cost that we would have to pay coming out of the all requirements project. This letter from the FNPA estimates that cost would be about $47 million. I think, Jim, you have a decimal point number there,
46.1.
$46.1 million.
Not including the 3.8 million that could potentially be.
From the Taylor's Creek,
Taylor
Taylor
swaps.
swaps, Taylor Energy Center swaps. Now, this amount is due, if this is the correct amount, in July 2014, because
No, July 2016.
2016.
Correct.
Okay. So it's due that date because that's the date we're getting out. No.
That's correct.
Okay. So this doesn't really have anything to do now with the sale. This is a standalone issue in my mind. We're either in the all requirements project or we're out of the all requirements project. The FNPA says $46.1 million. That's their number to come out of the all requirements in June of 2016. I have some questions about and some big concerns about that. And I think this is what you were referring to earlier when you were talking about redacted documents.
That is correct, yes,
Okay.
to justify the 46 plus the 3.
Okay, well, now, so again, for background, there are two sections. Under the contract, Section 29C, number 1, deals with bonds and debts. And that amount's calculated based upon our load. And since our load is 0 under the CROD, which, again, it's an amazing thing, Mr. Whittle, you all did to get the city everybody to save electricity to get us down to 0 CROD. Our obligation under section for bonds, any bond debts, is 0. The Section 2 deals with the stranded cost. And the FNPA has come back, and that's these numbers that the $46.1 million is stranded cost. I think if you look down at the footnote, what you see on page 2, it's all costs reasonably paid or incurred, reasonably anticipated to be paid or incurred, or reasonably projected to be incurred by the FNPA as a result of the withdrawal of the project participant over the term specified in the project participant's all requirements power supply contract. There are a lot of things in that language that I find, very interesting. First of all, they have to be stranded cost. Now, the amounts are determined by the FNPA in its sole discretion. But the FNPA doesn't get to determine what a stranded cost is. A stranded cost is they don't get to just define something as a stranded cost if it's not a stranded cost, and a stranded cost is a term of art in utilities. So, and in large part, that might come back to the Taylor swaps too, as that. They have to be reasonable. And that's the basis that we've gone and asked them, how did you calculate it? And so I don't think they have any grounds to not show us the reasonableness of their calculation.
Oh, and they have told us that they're going to show us that. They just wanted to prepare us that some of it could be proprietary information that we would not be able to release to the public. And that now, the other side of that coin is obviously you could litigate as to what's proprietary, because if it comes redacted and there's somebody that thinks that it's not proprietary, you could file suit. Now, FMPA is not the one going to declare proprietary. It will be the individual corporation or entity that has provided that information. So, for example, if Southern Company has given some information to them that they used in their calculations, then that Southern Company information, you would have to go Southern Company and have them determine that it's not proprietary. But yes, it would be questions in there. My concern, and Mr. Chairman, as you and I discussed, even if we got the number down to $30 million, we don't have $30 million.
I understand.
And so and we wouldn't want to build that into our rates.
No, we don't. But we also have to look at this. If we stay in, what do they recover?
100% of it's recoverable, but it's at the end of the period, which could be forever. I mean, so we are a responsible party for whatever that liability is. But example would be the Taylor swaps. If interest rates went up and the Taylor swaps became value added, then obviously we get a benefit from that in our rate structures. Typically how FMPA does things. They don't write checks, typically speaking.
Well, if the interest rates go up and we benefit in our rate structures, how do we benefit since we don't get any electricity from the All Requirements Project?
Through our other contracts with FMPA, they share that. What we have been told is that they would share that with us, and they would do that through our other contracts that we obviously have for our base load. And but the rest of it goes in. For example, the Stock Island, Cane Island. Some of these you read about, but you never thought that we were even part of those discussions. But supposedly they reserved capacity on those, and those are the type of issues that we need to sort of flush out and figure out what kind of capacity did they reserve for us prior to them knowing that our CROD was going to be zero. And they're predicating a lot of their numbers before they saw our final CROD at zero.
And the if they had stranded cost at some point in time in the past, and then they've used those costs. If we think of it as a spool of wire, they had a spool of wire for Vero Beach. And because we're leaving the All Requirements Project, they'll never use that spool of wire. Then we have to pay them for that spool of wire. If they've used that spool of wire in another project, even though they bought it for us before, it's no longer a stranded cost, it's a cost that's been used. So with respect to these plants, as they've had growth in the system, I'd like to see the calculation showing how they've used, how these stranded costs have been applied. I don't believe I'd be interested to see how that's been done. And it's another interesting thing that is the stranded cost for the fuel spill at the power plant, $3.5 million. I think that it's very important that we clean up the power plant and that we stop that fuel that they obviously know there's been fuel spilled there. And I think we need to start the cleanup.
Mr. Chairman, we've already done that. As a matter of fact, we have a no further action certificate from the state for both of our fuel spills that we don't necessarily relate directly to FNPA.
There must be another one that FNPA knows about that we're not aware of.
We're not aware of it, and if they think that the no further action by the state was not adequate and that there's fuel somewhere else, then we won't know that until you start digging around underneath those pipes. But our latest inspection showed that we had no fuel leaks in our pipes. We've emptied one of our tanks. We documented the 2 certificates from the state, no further action required, and we disposed of.
But they must have a reasonable basis for this $3.5 million figure.
Yep.
Otherwise, they can't assess us the $3.5 million.
Reasonable is the issue, yes.
Well, you're assuming they're reasonable.
Well, we have to assume that either they're reasonable or a court will determine reasonability.
So let me understand. They're presuming that we have cleanup costs associated with our plant that we don't know about?
That is correct. Mike, just to let you know a little of history, we, in our all requirements back in the old days when we first got into this, we actually bought and sold power from our power plant. And in that transaction, theoretically or technically, the fuel belonged to FMPA. Okay, so we were buying the fuel, generating the power, selling it off. The city and the FMPA at that time couldn't agree on pricing, so the city filed suit and all that other stuff we did, and eventually gave our 5-year notice. During that window in which we were using theoretically FMPA fuel, what they're saying is that it's reasonable to assume, because you've had these 2 oil spills, even though you cleaned those up, that there could be additional oil in the subsurface that could relate back to FMPA. And so therefore, they have determined that that's worth this $3.5 million. Now, we haven't done that, but the other side of that coin, for example, you use Fort Pierce. Fort Pierce didn't know that they had as many environmental issues as they have when they started digging around their plant, when they decommissioned the plant and started cleaning up the site, which they're still doing today. But there is ways of cleaning up a site. What you do is you state a standard that you want to follow with the state, and they set the standard of your cleanup. And for example, in Fort Pierce's case, they wanted to do residential homes. And so their cleanup standards was considerably higher than my recommendation on that site. We would use that as probably recreation, so therefore our cleanup standard would not be, because we show no migration, no movement of any fuel, oil, or anything to the lagoon. We have monitoring wells, and we've done everything that is required, so therefore there's no reason to dig, in my opinion, dig any deeper than we have to. We're not going to put houses there.
So they're applying some statistical model, their experience or something like that, just assuming.
Yes, sir.
So it's not based on any actual knowledge. It's just based on, like I said, a statistic.
That is correct, and an assumption on somebody's part.
Yeah. But at the end of the day, they're asking us to pay them for a liability that we'd be cleaning up anyway.
That's correct, and we get 90% of it back if there is nothing associated with FMPA. But they keep, see, that's the other little issue here, is that the $46 million, they keep $4.6 million of that at worst case scenario. And so therefore, when they set a standard, now, again, on the FMPA side of it, because dealing with all parties here, FMPA only gets one shot at setting a standard of their exposure, and that's now. It's 16. When we leave, we write them a check. They can't come back to us, for example, if there was fuel now leaking into the lagoon and we labeled it as FMPA fuel, they can't come back to us for any more. So they have to price at the maximum that they think the exposure would be. And that's where you get into the way the contract was written. You know, it's sort of, to me, it sort of encourages somebody to set the bar pretty high, because you're keeping 10%,
Yeah.
but at the same time, and we signed the contract.
So essentially, they get $46 million. They don't pay us any interest, and they can do what they want with it, and yet they may not have to pay anything out of it.
That is correct. If there is no exposure long term, then they give us
So they got a hell of
90%
a
of
deal.
that.
Yeah.
They keep 90%, or we get 90% of the number back.
Yeah, but I mean, some of that 46 may be 10 years before they have to spend it,
That is correct.
and there's no
Could be
interest.
even longer than that in some
Right, and
cases.
there's no interest to us at all, which is
That is correct.
usury as far as I'm concerned.
Yeah, we write them the check, and that we have to write them the check the day we get out of all requirements. There is no flexibility on that under the contract.
Do our
Jim,
lawyers
are
totally
there,
agree with that? Do our
Pardon
lawyers totally agree with that at this point, or is there any discussion about that? Having to write
There
the
is
check. right
discussion.
there.
There is about writing the check.
Yeah.
Oh, there is no discussion about that. That's pretty clear in the contract. The question is defining reasonableness and what is that number that you have to write upon exit.
Jim, are there studies available that I'm sure of these Phase 2 audits and remediation that was done at that plant, are they available to the public for review?
Yes, ma'am. We have, and I think it's on our web, the Phase 2 report from FP&L that they did on our site. And it notes both of those. And at the power plant, we have all the background that anybody would want on what's taking place there.
I'd be interested in reviewing that.
Okay.
Thank you.
And I think Tammy can tell you how to get to that
Okay.
on the website.
I think that it is important that the reasonable issue, but also what are stranded costs. Again, they can't define stranded cost.
Well, they're attempting to define it in this letter.
Well, they are. I mean, they can define the amount, but they can't call something a stranded cost if it's not a stranded cost.
That is correct. For example, Stock Island, 2005, that's on their list. You know, I have no earthly idea. We would have to do a lot of research to find out where we were in Stock Island at that particular time. So,
and we do have, and they have prepared and given testimony over time back in this time frame showing zero projections for Vero Beach. So there's a lot here that's a lot of facts are in dispute.
yeah,
That doesn't go to the essence of the contract.
again, the answer to the question is yes, there's always room to dispute the dollar amount, and at least we have a quantifiable dollar that we're working with. My concern is to spend an awful lot of money fighting over the 46 and it becomes 30. I'm still in the same situation I was at 46. I mean, it could be 100 million as far as that goes. The question is can we drive it below a number that is affordable? For example, at one of the meetings when they had their first run at numbers, I mean, we were talking about 7.2 million or something like that, and I thought, well, I didn't say it out loud, but deep down inside, I thought, well, that's an achievable issue, an achievable number. But then when it gets up into the double digits, we just don't have it.
Right. Well, I think we need to definitely look at this.
Well, if you can't afford it, what happens?
Well, we could make an application back to FMPA and say that we have changed our position and we would like to hold in abeyance our exit from the all requirements and hold that in abeyance, but still get credit for the time served. Excuse me, that shouldn't. The time used.
I think that's an appropriate
the time
word.
used, and sort of hold it until we get to a period of time that we feel like that we can to make that happen, and possibly the numbers will go down over time. I mean, and hopefully that would occur. So if we did the closing later, then theoretically they would have the Taylor swaps taken care of and some of these other issues, and they sort of drop off the face.
Well, the Taylor swaps come up before 16, right? They come
That's
up
correct.
15.
15.
And we don't have to pay this till 16. So.
That's correct. And that's why they didn't really include it in their calculations, because that could be due before.
I think with respect to the Taylor swaps, I think it's a good illustration too, again, of my discussion about costs that were incurred at a point in time and then not used or used someplace else. The FMPA has done other financing. They've had other financing transactions since the Taylor swap, since the Taylor Energy Center. They had the opportunity to use these swaps to finance the different projects that they've had going forward. They've chosen to not use them for those projects. They made a decision to not use them, and probably because it was more economical to not use them and hope the interest rates would come back up. But every time they did that, why aren't they now the Emerson swaps? Because they could have used them for Emerson, but they chose not to. So why are they still Taylor swaps? every time that they don't use them, they've effectively repurchased them. And so I think that it's frustrating, and it's a difficult thing. But when you have cost that you've replaced someplace else, you can't leave them out there and claim they're stranded cost, because they're no longer stranded cost. So I think there's a lot here that we need to look very carefully at how they've done this and how this needs to be done. And hopefully Mr. Wright will be able to help us with this.
He is working on that, and once we get a document retracted or otherwise, we will send it out to you folks as well.
Okay, thank you. Any other questions?
Is it a fair characterization that FMPA has simply made this as difficult as they possibly can for us to get out?
Mike, I think the issue is we signed very complicated and difficult contracts that said we're not going to leave FMPA. I mean, you can read through all of those contracts and you look at them. The fact of the matter is somebody somewhere, either consciously or subconsciously, said, we're not going to leave FMPA, so we're signing the contracts. We could hold FMPA responsible, but the fact of the matter is FMPA is an entity that's made up of a bunch of cities. It's not like Florida Power and Light or Duke Energy, or it really is more like a co-op, in which you are dealing in and amongst yourselves. And in theory, a bunch of cities sat down and said, I want to buy a piece of Stanton plant. And they sat down with their attorneys. Now, this is in the ideal world, and I'm not really sure this actually occurred. Sat down with their attorneys and said, let's write the best contract we have, because we think Stanton plant, Stanton 2, is going to be the best fuel, best energy, heat rate that we're going to be able to get in our area. And we want to sign on and make sure we have capacity reserved for the city of Vero Beach and whoever else bought into that. And so you had this attorney that theoretically worked up a contract and came back and said, this is really the deal for you. We're going to get very good interest rates because we have a lot of security. We pledged your 34,000 customers, and we pledged all your future meters, and we pledged the fact that you're going to be a going concern, and we pledged the fact that the state gave you this service area, and you're in a great state of Florida because the world is growing all around you, and meters are going to keep spinning, and it's a cash business. And somebody signed that contract.
So but that was predicated on the notion that we'd never leave.
Yes, sir. I don't know any other way, in my opinion, and I'm not an attorney, nor do I play one on TV, but in my opinion, when they sat down and signed those contracts with all those clauses in there that had the backlash, for example, we can reasonably set whatever exit number that we want to set for you to exit this contract, and whether it's $46 million or $100 million, and you're going to let us retain 10% of that just because we have overhead or something.
And so no reasonable person would sign that, so it must be because it was assumed that it would never happen.
Yes, sir. That would be an assumption on my part and a conclusion that I would draw, that nobody would have ever expected to have that imposed upon them.
Jim, did you tell me, somebody told me over the course of this contracts, this last few years, that Fred Bryant, the FMPA attorney, offhandedly said that he never anticipated anybody actually would leave.
His comment was, he never anticipated that you would sell your power supply contracts to any other entity other than an FMPA qualified entity. And he's made that statement several times, and that all these contracts were developed under the premise that your market is going to be a restricted market, but it will be a market to qualified entities. And for example, Jacksonville, the city of Jacksonville Electric Utility is not a member of FMPA, but they are eligible, so you could sell, if they were in the market, could sell to Jacksonville Utilities. Theoretically, I guess, you could sell to an entity, well, I don't know, it depends on how the state law is written, but if you sold it to the city of Gainesville, Georgia, if they could become an eligible entity for FMPA, then they could buy your power supply contracts. But he has made that statement several times.
Which is why we sold our power supply contracts to OUC.
That is correct.
One of the other issues that's come up is that we should have resolved these issues up front. But I reflect back on a 2006. We went to the FNPA and we asked them to respond to the framework of a deal. And we said, we were looking at a sale or something. They said, well, we can't respond to a general framework. We need to know a specific deal. And you bring us a deal, and then we'll tell you whether that work or not. And so based on that, we brought them a deal. And we did follow, and they suggested at that point in time that we follow, I believe it was the Homestead model. And we did follow the Homestead model, was we put together the OUC. And then we took it to them. And now after we did this, then it reached this place where OUC and FNPA cannot agree on their various bond requirements. But in 2006, they said that they couldn't give us an answer absent a deal to review. So we could not have, at the beginning of this process, gone to them with a framework, because they've already shut us down on a framework. They said, bring us a deal. And I think that's an important thing that we need to keep in mind as we look back at recriminations and wondering how we could have done it differently. We tried to do it differently in 2006. They said, no, bring us a deal. So we brought them a deal. And FNPA and OUC could not come to terms.
Mr. Chairman, if I had started this in 2006, I don't know what condition I would be in today, probably in a mental institution somewhere. But in the 3 years that I've been here, when we first sat down with FMPA, what you said is exactly right. They said, you got to bring us a deal and you've got to remember your power supply contracts are a critical element of this whole thing. Now, Fred was very clear, you still got your bondholders and your bond counsels and all these other people, but you've got to have a mechanism to get rid of your power supply contracts. Our first effort was with FMPA. As you recall, we went through a period of several months where we asked FMPA to do a request for proposals from their member cities and anyone that was not necessarily a member city. Would they be interested in buying our power supply contracts? And we got a few positive responses, but they were very small in number as to the megawattage that they would take. Our next deal is that we would go to FPL and say, okay, how can we structure a deal where you take the power? We could never get over that hump of 3 years with the IRS. It was infallibly put into the rules. We couldn't get there. So then we turned to OUC and said, okay, you're the maker of this power. How can we convince you to take these power supply contracts? And they said that they would take, after the 3 years, based on us paying $54 million in order to give them cash there and then sell the 3-year window. So they didn't want any part of that and made it very clear. So we had to take time to structure that contract, and we tried to address as many of the issues as that we could possibly do, which meant we had to keep going back to FMPA and saying, okay, here's one concept. And our attorneys caught a lot of grief for coming out and saying it wasn't really selling of the system, it was actually the transfer of the system. What we were looking for is verbiage that FMPA could reasonably accept that would go into a contract. As we all know, when an attorney puts a contract together, the terminology used in there can be defined in the footnotes somewhere, but you try to get the right terms that doesn't allude to that you're violating the law in any form or fashion. And so we were trying to make those contracts read that were reasonably acceptable to the member cities of FMPA. And when you went to Kissimmee or Bartow or Bunnell or any of the other cities and said, this is the transaction that's taking place. It gives you plenty of security for the bonds. If something should happen, we are more than covered because we found a good replacement. And so that was the total effort. I agree. I don't know about the 2006, but we were told pretty well up front you had to address the power supply agreements. But you also had all these other issues that you had to make, and we, for a long time, did not accept the fact that we were going to have to go out to every city and then come back to the board of directors and do all of these things. We were sort of relying on the fact that a lot of times FMPA makes decisions through their board of directors, and it's not necessarily through the cities. The board of directors makes a vote. They write up a resolution, send it to the various cities. The cities vote on it, and it happens in less than a month. And so we were trying to work that angle that we felt like if we could convince Fred and Nick and Jody and the folks that were the staff people, and if they signed off on it, then we could work. And that's a lot of the issues of negotiating in the public light like we did. And again, when I was hired, they said they wanted it as transparent as possible. I don't know how you could ever do it any more transparent than this has been. But a lot of that leads to speculation and issues. But to answer your question, in my opinion, we could have taken a couple shortcuts maybe, but I think in order to address and do all the hoops, we had to go through that exercise.
Okay. Thank you very much. Any other questions from the committee? Public? Mr. Wilson?
Wilson, 2134 18th Avenue. Thank you very much. I really enjoyed this discussion and a couple of things that we learned. Thank you, Jim, for all of your information. There are three things that I learned this morning. Despite all of our differences in the past, some people on this commission and in town fought hard against the sale. Some of us fought hard for the sale. Despite that now, there's three things that we know. The first thing is that things can get worse. They can get a lot worse. The things that we've talked about today with the carbon tax and the new federal regulations and just the FMPA not having any restrictions at all in what they're able to make up or decide or do for themselves. So the first thing we have to recognize is that things can get worse. The second thing that we have to recognize that I learned this morning is that legal action is inevitable. That it's not a case of whether we're going to have a legal entanglement or a legal discussion with FMPA. As Mr. O'Connor said, the only people that are going to be able to determine reasonable is going to be a court. So the only two choices we have is the inevitability of legal action or number two, get over it. Those are our two choices. We can either stay with the FMPA for generations into the future and do the, quote, get over it, or legal action is without question. And the third thing that we've now learned, and thank you to Mr. Ostner, the third thing that we have now learned is that the FMPA, and I'm going to use this word, the FMPA could bankrupt us. Okay. The fact is that the one protection we have of not bankrupting the city is that we have not pledged the city's taxes into the future. And learning that was part of the discussion is frightening, because the fact is an unbridled, unregulated monopoly that has no requirements for reasonableness or just any decision that they get to make in some omnipresent fashion, that they could, in fact, bankrupt us. But at least at now, the only thing that they can bankrupt is the utility and not the city. The fact is that one of the things when we're talking about these contracts that were looked at in 1983, it's interesting that we keep saying that that the FMPA did not anticipate selling to anybody else outside of the FMPA. It seems like when you're in a co-op, part of the idea of a co-op is that you can get out of a co-op. What we're in is a cartel because we can't leave. This is like, as Russ Lemon said, the Hotel California. We checked in, but we can't check out. Right? So what we now have is we're faced with the future of our city. Nothing less than the future of our city. We can't keep Vero if there is no Vero. So the things that we're facing, the things that you're discussing, and I thank the Chairman Scott Stradley for his in-depth knowledge into what we're talking about, because this is a place where we do get in the weeds. The public doesn't understand where we are, but the public also doesn't understand the dangers of where we are. And I want to point out that I believe that the entire tax revenues from the city is what, $4 million? What the FMPA has picked out of the air is $50 million. That's 12 years of taxes. All of it. The police department, the building department, city council, all of it that we're facing with this organization. So the reason I rise again and thank Jim for this information is because this is becoming very clear. Whether you were against the sale and made commercials for the FMEA, or you were for the sale like I was, the fact is right now what we have to do is get on board together, because we have to prevent what is this train that is coming at us. It's really strange. Somebody asked me how everything was going, and I thought for a minute, and I said, well, let's see. The lagoon is dying, the electric sail is dead, and the train is still running. So it looks like we're probably not making a lot of progress in the way that the public wants us to go. Now, so that brings us back to what do we do? There are still only 3 things that we can do: legal action, regulatory control through the Public Service Commission, and legislation. Okay. So I appreciate what we're looking at, but the main thing that I want everybody to know, and the public should know from this meeting, is look out. FMPA will kill this city. Thank you.
Okay, thank you very much, Mr. Wilson. Any
Jim, the current project costs in one of these letters is St. Lucie $7 million, Stanton.
Herb, could you tell us which letter so we can all be on the same
Well,
page?
it's page 1. I think it's one of the June 4th letters anyway. It's page 1. And right at the top, it's description of project cost, City of Vero Beach. And you got 3 projects. We pay that every year over and above what we buy. You got St. Lucie project $7 million, Stanton project $8 million, Stanton 2 project $7 million. It's the one that has the examples.
Yes, sir. That's what he is indicating in this.
So we do pay that over and above what we pay for fuel.
That is correct. And that's what he is referring to as part of what they cannot quantify, because those numbers will continue to rise, or could continue to rise.
Now, do we actually own part, or do they own it and we get this because they own part of it?
We actually own a part of it by contract. It's in the title of FMPA, but we own that proportionate share of that title.
Okay, now if one of these power plants makes a profit, does anybody get the profit?
profits come out in the form of rates. So the rates go down if there is a profit. For example, when we sold to the Southern Company, our rates came down, or some of our costs came down the following month. So
Actually, Jim, I don't think we own an interest in these power plants. We have an obligation to buy megawatts and an obligation to pay the fixed operating costs. But I don't believe that we have an ownership interest in either one of these. The FNPA owns them, and our power supply contracts are not ownership. There's power supply contracts.
Well, again, that's an auditor talking. What I am being told from a legal standpoint is that we actually have ownership obligations by contract to these facilities.
We have ownership obligations, but we don't have ownership benefits. We just have the obligations.
Right. But theoretically, if they make profit, again, it's a municipal, so profit is a relative term. But if the prices go down on the unit, the price for generation is supposed to go down. We benefit from the lower cost of that generation, because it's not like it's going to stockholders, theoretically. But now, OUC, as most municipals do send money to the general fund of the cities. So in theory, they're making whatever their percentage of markup is.
So they send that to Orlando?
Yes, the city of Orlando does benefit from the Orlando Utility Commission.
Thank you.
Mr. Mucher.
Mark Mucher again. Real quick, a point of clarification. I had never heard a July date before, and the only date I can find in this June 4th letter is October 1st, 2016. So I
think that's correct.
Wanted to correct that.
Yeah, I was wondering about that myself.
Thank you.
Okay. Is there anything else?
It's along the same lines, or part of this, that right now we're obligated to FMPA and other people for the money they spend in research, et cetera, toward the sale. Have we shut that off, or are we going to?
We have paid their bond counsel cost and any external cost that they chose to send to us. For example, their bond counsels were like $700 an hour or something. I think it was $750. And so whenever we met with Art McMahon or FMPA, for example, we paid for the letter that Art McMahon would generate. We did not pay for the staff cost, because our position was we are a member of FMPA, so therefore we are part ownership of Fred.
Have we done anything to stop this? To say, okay, if it's dead, it's dead. There's no sense in you spending our money to do other things?
I don't think they need any more legal advice. They got the final letter from him. Unless we go back and inquire, then as far as we're concerned, we've got their final document. So now what we're doing is trying to look at that document, analyze that document, and then talk to Florida Power and Light and see, is there another option or alternative that we can explore. And just for clarification also on this litigation thing, everybody can sue everybody, which is the way it is. But I keep coming back on that quantifiable number, 46.1. Even if you went back and we said unreasonable, more than half of it, we still don't have $20 million. And that's only one element to get out. So I'm not advocating that we file suit to try to work on that $46 million. I think that once we get that letter, hopefully we'll get something that sort of justifies where it came from. We can sit down and discuss. But I'm just not sure that we could ever ratchet that number down to where we could write a check on October the 1st, 2016.
Well, I'm wondering if maybe there are items on that list or indicated by that list, items of stranded cost, that our legal team might be able to say, we're literally not obligated for this.
That's what we're shooting
And
for. Yes.
when we get that, we should take an aggressive stand of sending them a letter that says, no, we're not obligated for that, or we're obligated for less, or whatever it is. And then put them in the situation where it's not us having to sue for that item. We just say, we're not going to pay you because we don't need to. And if you want it, then you've got to sue, and that's a whole different ballgame.
No, sir, they don't have, they do have the right to sue, obviously, but the only thing they can say is you're not out of the all requirements till we received your check. I mean, that's,
Well-
so they, but the fact of the matter is, that's why we're asking for the backup, is because we want to make sure, and if there are those items, we obviously will take issue with those.
And if we don't give them the check, what happens on the oil requirements?
Well, technically, we would not be out of all requirements, I would presume, and then they would probably litigate against us for that money.
The going back to the question that you raised about their attorney's fees, unless they're doing more work for us, there won't be any more charges. I doubt we've paid for this letter at the end of May because the attorneys send the bill to FNPA, who sends it to our attorneys in West Palm Beach, who send it to us to pay. So I doubt we've actually gotten that bill yet. So there will probably be a little bit more. But the deal's not dead. We still have a contract with Florida Power and Light. We need to keep that in mind. It's, as I think you said, it's on life support.
Yes, sir.
But
was by now.
it's not dead yet. So we're.
I
so-
understand that,
But there won't be any.
I was just saying, and I think I've been answered.
Yeah, there won't be any additional cost
There
unless
shouldn't
we.
be any, and you're watching that, and only if we ask, and that's okay.
Right.
That is
But at this
correct.
point, there's no reason for them
That is
to
correct.
add more right now.
Yeah, and I think, but I think the idea of having them come after us might not be a bad way to do it, and maybe they would, because the thing is, we have to ask them. Pretty please don't charge us this $46 million.
Yeah.
They don't have to say. We've asked to be out. All they have to do is not approve a deferral or letting us back in, and they bill us for the $46 million. And I don't know, I don't know what that would do to the utility. That would probably bankrupt the utility. And whether that obligation would then flow through to the city itself, I don't think it would.
No, sir, there's no flow through to the city itself, but there is a flow through to the 34,000 customers.
Which would be
Whoever acquired them, using the Sebring issue, Sebring's customers had to pay surcharges because of the investment in the plant the city did.
It would be interesting to see what would happen politically if the 34,000 people were paying $300 a kilowatt hour for electricity going forward. So yes, there's a lot going on here. I think people would just stop paying their bill.
Yeah,
Would that-
and I don't think you'd collect it all in 1 month either.
Would
Yeah.
that be for just Vero Beach customers or for all existing customers?
The pledge is the 34,000 our service area.
So all existing customers.
Yes, sir.
Okay.
If that is what has to happen, then that would be a fairer way of allowing
Fair.
the utility customers to pay their way out.
Hopefully, we're not going to get to that point.
just-
So it's
Okay. Well, yeah, we're not going to get. Hopefully, we're not going to get to that point. Any other questions? Any other items?
So where do we go from here?
Well, the city has. Go ahead, Jim.
Mr. Chairman, recommendation is to let us continue to explore the options and alternatives through our attorneys in collaboration with the Florida Power and Light, and to see if we can figure out a way. I'm not sure the Utility Commission could come up with, I may be wrong, you guys may have the answer, but I think it's a combination of the legal issues as well as the technical issues that we have to sort of work through. And our conversations, as I said, as of this morning, I had a conversation with FP&L as well as our attorneys, and so we have a dialogue going. The question is there something reasonable that we can to work out? But we've got to continue to explore the options for reducing our rates, and any one of those is the power plant. We hopefully will get that letter out within the next couple of weeks or so to make sure that we have all the technical issues addressed as to what we will need in the transmission study and what our expectations would be. And then part of that conversation is going to be how do we acquire the capacity in order to support what the plant was providing. Then at the same time, we have to work hopefully with OUC and FP&L to try to get through the technicalities. If we let the contract continue on, the technicalities where we can sit down with OUC and start talking about some of our demand charges and how they set our capacity numbers. Because under the contract, they have the right to set the capacity numbers.
But so one of the options is, continued discussion, dialogue, as you said. But we're having dialogue with someone that almost by definition is not listening. I mean, the FMPA, they never anticipated anybody leaving. Everything was written so that nobody was expected to leave, and as a consequence, they don't think, at least it seems like they have no intentions of letting us out. So that one, even though it may be sound like a good idea to keep having discussions, as a practical matter, they're not going to come to anything, or so it would seem.
That's why my description on life support is the issue. But at the same time, I will tell you, we've had teams of attorneys poring over these contracts, and no one has been able to identify a crack in the armor. I mean, from our standpoint, the city was a willing signer and executioner of a contract. And a case could be made that we were actually part of the development of the articles in that contract. Again, going back and using the analogy that I did, it's just like you sitting down with your attorney saying, I want a piece of that plant, and you theoretically sit down and go through all the little issues and you check off, yes, I agree with that, I agree with that. And at the end of the day, you bring that back in front of a public body. You voted to say yes, and you move forward under that contract. And, we can all talk about litigation, and under the stranded cost, you may be able to work through that, because I think there are some weaknesses there. We haven't seen the documentation. We have to go and see some of that, and I think there somewhere in there has to be something challengeable. But in the other contracts, I'm just not sure. No one has indicated, and we've had, again, teams of attorneys look at this thing. And so from an organization that actually signed up on the contracts, I'm just not sure where we are in that.
So then
process.
the next best option is reducing the rates.
Yes, sir. Yeah, we've got to do that.
Thank you.
Mr. Wilson.
Very quickly, sir, I want to point out just a couple of things. The direction that this commission, as well as everybody else, has and what to do now is get over it. That's the direction from at least the one of the city council people. I'm not sure that's the direction we all will take. Mr. O'Connor, of course, is much smarter than I am, and I understand that, and much more knowledgeable. At the same time, it's not just me talking about litigation. It's Indian River County, and it's the town of Indian River Shores, who are perfectly are going forward with exploring litigation. And to answer one of the commissioner's questions, and I heard the answer Mr. O'Connor gave, that yes, of course it does all ratepayers, outside and inside. And I'm not sure that the county and the city agree with that. So I think I tend to believe certainly Mr. O'Connor's position, but I think we should at least recognize that there's some people that believe that the people in the county and the town of Indian River Shores have certain obligations that are different than the people inside of the city of Vero Beach. And the place you can find that most evident is in the case that they're talking about that supposedly reviewed all of these things in 1983. And it lists the plaintiffs and it lists the defendants. And part of the thing that it lists in the defendants of these bonds being issued is it lists all the cities all the way through Florida, and it says property owners residing within or owning property within the municipal limits. So that 1983 case does not even list outside ratepayers. The second consideration is I don't understand, and I know there's a lot I don't understand, but I don't understand how the ratepayers outside of the city are obligated for all of the obligations. For instance, they're supposed to pay all of the costs associated, even though they have no representation, didn't vote on it. But when we were going to sell and we had revenues, not one time did I hear anybody say, okay, well, $40 million of that money has to be distributed to the ratepayers that were outside of the city. If you're going to be responsible for the liabilities, then you also get the assets. So I think to just automatically assume that the city of Vero Beach, this is one of the reasons the city of Vero Beach, the residents of Vero Beach are in such dire jeopardy, because it may be that they get shared by 34,000 ratepayers, but it also may be that it'll be their single. 1/3 of the people will carry the entire burden for this. Again, we'll see. Honorable people can disagree, and courts can do strange things. For instance, when they say that you can't sell to anybody else, it kind of reminds me of restraint of trade. I'm not sure, but the very basic for. So we may not be able to attack the contracts, but we may be able to attack every single part of the contracts that makes it so onerous to us. There may be alternatives. You may be able to have a separate utility. You may be able to have a holding company that does the things that are required it to do, and yet not have the ability of the FMPA to just willy-nilly go out and borrow as much money as they want and continue to extend over and over and over again. Those are the things that cause us problems. And yes, we need to get our rates. We need to concentrate on our rates. But I remind you that we have been promised rates as low as FP&L since 1976. And we have been shown over and over and over again that the city of Vero Beach will be slaves to higher prices as long as we're part of this organization. And so I believe that we should adopt where we go now is that we will do anything, go to any measure to get away from these people, to get away from this organization. If I had cancer and somebody told me that I had a chance to take a very expensive treatment and it only had 10% chance of curing me, I'd still take it. And the city of Vero Beach, the worst thing we could possibly do is not go aggressively to every single possibility for getting us away from this organization, no matter how small. Thank you.
Mr. Chairman, if I make
Sure.
one more statement. With regard to lowering the city rates from the perspective of Indian River Shores, just stop transferring quite so much money into the city coffers, and that would and give that credit back to us. Or we made a recent deal with the city for water, and where you tied the rates to the county, so you could just tie the county or the shores rates to the FP&L rates, and we'd probably be pretty happy.
I think the first suggestion is maybe one that we should look at, because one of the big things that we could do is to lower rates is to zero out the transfer. That would lower the rates about $4 to $5 per megawatt hour. a lot of the justification for the transfer that I've heard over the years is that it's a rate of return on the city's investment. Except I don't see where the city's really invested anything. The ratepayers have invested. And so unless we're down and have our rates down to at least the average for the municipal utilities, I don't really see any justification for any profits. Profits, the concept of profits in a monopoly are kind of a squirrely thing. And you know, if we could have even more profit if we charged even more money, and there's no control on that. So if we can't provide electricity at least at the average market rate for the other municipal electrical systems in the state, I question whether we have any profit that we should be transferring to the general fund, and that's something that maybe we can look at. And with respect to what we do, I mean, I think your question was very relevant. What should you do as the Shores representative? Because you have to make a report back to the Shores, and the Shores is budgeting money to hire an attorney to pursue litigation, as the county has, and that's been mentioned. And I haven't heard anything today that I would be surprised if you were to go back and recommend to not do that, based on what you've learned today. By the way, I appreciate you for your first meeting. We probably should have introduced you at the beginning and had you give a little bio, but you got off the hook.
Mr. Chairman, if I may, the Finance Commission is looking at reducing one of our SWOT analysis, reduce transfer fees to and from the general fund, raise taxes. And that was one of the items that they are taking up for consideration.
Okay. Very good. The what we can do, what we need to do is we need to continue to monitor the utility. We need to make sure that the utility is operating efficiently, both utilities. We need to look into some of the issues in this All Requirements project. We received a copy of a letter about 2 months ago, maybe in late April, early May. I had raised some questions about the fact that the outstanding bonds on the St. Lucie project had increased by about 50%, 75% over the original acquisition price. And we received shortly after that, not direct response to that, but subsequent to that questioning, we received a letter from the FNPA talking about what they did with their bonding and showing all the other projects are down lower. Their bonds have been reduced, and the only thing they seem to say in that letter is that the board of directors approved the increase in the funds, and that they were able to borrow more money and keep the actual cost the same to the ratepayers. It still didn't answer what happened to the extra funds. So maybe we should get that letter recirculated and put that back on our agenda to look and see if they've answered those questions. I think that we need to we need to go forward. We need to make sure that the contract obligations on all sides are being adhered to. And I think that I talked with Mr. Gorey about some of the analysis that had more to do with operations of the plants and the utilities, about bringing those to us, and some of the ones like the financing, the transfer to the general fund is something that really should go to the Finance Commission. So we'll be looking at those. We need to look at try to mothball the plant, what those costs would be. We talked about that a little bit earlier on today. We need to save money everywhere we can and pass that through as lower rates. So that's what we need to do going forward. We need to bring the rates down. We need to continue to work forward towards the sale, because as we mentioned 2 months ago, Herb, you mentioned that you made a motion that the best option that we had to bring the rates down was the sale. And as long as the sale is not dead, only on life support, then perhaps it will have a miracle and she'll wake up from the coma. And we can go forward with the sale. But we'll see. And with that, I would look for a motion to adjourn. And we'll
Wait a minute. We need to talk a little bit. I'd like to talk a little bit about water and sewer, which is part of us. And one of the things that we got a problem with, the lagoon just showed us that it's really a problem because we had a huge algae bloom. And, you know, Rob Bolton has tried to go and get the step system done. It didn't get passed. I actually gave a copy of a letter to the city council, which I gave to a bunch of other people, that I was requested to do by one of the council chamber. It's a one-page letter to the governor asking him to step in and try and get it approved. I can give this, and then we don't need to send it out. But
Well, why don't you send it out, and why don't we discuss that
okay.
next month, put that on the agenda for next month, and
But
because we had talked to the last time we talked about it, we were going to look for a regulatory waiver to do a pilot project down at
at the
McWilliams Park.
right.
And we can maybe get an update on that. And we can bring your letter up. I'm very well aware that we do have two utilities, and I really like it when we get to talk about water sewer a little bit, because that's very, very important, and the lagoon is very important to me. But I also like to keep to our agenda and to have the public have the information.
I was doing this under members' matters. But there was also a meeting, and actually the city of Vero Beach has done very well on its stormwater in that all of the outlets have baffle boxes now. And we're probably the only city on the lagoon that does that. So that's a kudo for the city. All right, that's all. I'll give this to... Yeah, I'm giving both of these items and put them in the
great.
minutes.
And then Sherry can distribute them to us. Next meeting should be
Mr. Chairman, all the members got a copy of the letter that I sent to Cindy Lawson.
We did. We all got that today. And I think she needed a little bit more time to actually answer your letter. Mm-hmm.
The point I was getting at, she wasn't able to answer the full letter, but hopefully she will. But the point I was getting at is that we've been talking, and everybody's been talking strictly in terms of lowering the electric rates, 10 cents, whatever. But there's two sides to that equation. You can lower the electric rates, but at what cost? And nobody seems to be talking very much about what that cost is in terms of, do we have to float a bond for $46 million? And what would that cost the city and its ratepayers? Are there other costs? You know, we started off when this whole sale proposal started out with, I believe it was something like $115 or $120 million sale, and I forget the amount, but some significant amount of money coming into the city. At this point, it looks like we're just about breaking even, or breaking even. That's not quite the term that applies, but we're essentially getting out of the utility business with no benefit to the city.
Except lowered rates.
Well,
And also elimination of our unfunded pension liability. There's significant benefits, and I'm not sure where Mayor Winger came up with that $3 million number at closing, because that was $3 million after we'd satisfied all our liabilities, including our pension liability. And our unfunded liabilities across the whole system, not just the utility. There is a significant, I mean, if we were to look at the sale, the way the sale is structured now, there is a significant benefit to the city. Some of the, if you're referring back to some of the very early recommendations or the early analysis, no one knew 4 years ago that the liabilities, that these projects were so far underwater, that offering $52 million to the FNPA to take the utilities to these entitlement projects for 3 years wasn't enough. $52 million to the FNPA, $34 million to OUC is how far that, I mean, we're deeper underwater than that because that wasn't enough money for them to take it. Now, those facts weren't known. And those facts were developed through the course of negotiation. So the actual sales price of the utility is very consistent with the valuation of the utility. The appraisal of the utility did not go into the fact that these entitlement contracts had a negative value greater than $86 million. Some figure greater than $86 million is the amount of the liability that we're obligated to in these entitlement contracts. So all of these things weren't known. Now, the fact of the matter is we have, if we were to close the sale as it was structured, which now doesn't seem to be very likely, there is a significant savings, significant amount of cash that comes to the city of Vero Beach. And Mayor Winger has always said that what he looked to do with that cash was to pay off the pension liabilities and to fully fund our pension plan, then end the defined benefit plan, move to defined contribution plan going forward. After that, I think there was about $3 million left over. So but that's a significant benefit to the city and to the citizens of the city of Vero Beach, because we have an unfunded pension liability, which with the market going up is getting smaller, but all these numbers are very fluid. But I do, $300 a year, I think if we look at the, we'd need to replace $2.2 million is her figure. You can look at, right now we're raising about what, 4.1. It has to go to 2.2, so call it 50%. Okay, so look at your city taxes, which are 10% of your total tax bill. Increase that by 50%, and that's a pretty good ballpark figure for what your taxes would be. You'd save, the average resident would save about $300 a year. So that's a quick and dirty analysis of it. My personal taxes, my city taxes are we're right around $300. My total taxes for the county is about my total tax bill's approximately $3,000. 10% of that is the city. So if we were to replace the whole $2.2 million, if the city council, and this is why Cindy can't answer this question because it's a policy statement, but if the city council were to decide to replace that all through ad valorem taxes, my taxes would go from $300 to $450, approximately. My utility bill would go down $300, so I would come out $300 ahead. There are other people that it would be, there's some people that would be winners, some people that would be losers under this, as there isn't any sort of change to go forward. But by and large, the city itself would save about $8 million in electric and at the cost of a $2.2 million tax increase. So I think that there would be more winners than losers. But certainly we can look at this in greater detail next month, if you'd like. I think that, and with respect to the suggestion that we zero out the transfers to the general fund, or one of the suggestions that this Finance Commission put forward, maybe it's something to look at. And now in that situation, we're not going to get the same savings. But we're at least paying, we're paying for electricity what it costs us for the electricity. We're paying for the city. The city is, taxpayers are paying through their property taxes what it costs to operate the city. They're not transferring that to the ratepayers. So that's, that's a policy decision that the city council has to go forward, which may well be although subject to discussion in the next few months as we're having an election. So all of these things are useful things to talk about.
I'd like to take one exception, and that's that these are things that we didn't know about. We may not have known the details and some of the amounts, but we certainly knew about black holes a good 10 years ago. When we decided to get out of the all requirements project to begin with back then, we discussed the possibility of selling the utility and decided not to. And one of the major reasons was the bond issues and the FMPA issues that were undefined, but we knew were huge. And we knew it then, not just the last few months. So I don't want to beleaguer this, but just set the record straight a little bit.
Mr. Chairman, didn't we have a motion to adjourn?
No.
We didn't?
Not yet, no.
But never got one.
Oh, okay.
But if you'll make one, it's on debatable.
I'll make it.
Okay, do we have a second?
Yes,
I'll second it. All in favor? Aye, adjourned.